your thoughts on where you stand on this issue and what you make of the Supreme Court's intervention.
I think last Saturday I was on TV3, the key points. I'm sure by now. Oh, I'm surprised to say you haven't heard. Sorry, but I stated that what the Supreme Court did is shocking. That's not law. What they did is contrary to the practice. I mean, from too many things went wrong. Yeah, too many things. And I made a point that so the Supreme Court is giving credence to citizens' belief that they are more political than anything else. Yes, that's what I stated. And I'm sure you've heard other commentators mentioning that they could see the political angle in this decision more than anything else. You hear Ansari the same point. You hear Dr. Mami Mensah-Bonsu. You hear Ansari. You hear Kwame Nkrumah. Even Kwame Nkrumah, who is an MPP, at least he's close to them, even if you won't call him a member, because I don't know that he has expressly said he's a member, but he's close to them. You've seen all that. So most commentators are very clear that this decision is really not a decision. It's just absurd. I mean, why the rush? Or the Friday after, something was filed, I understand, around 10 something. And then in the next 1 hour, the Supreme Court, 5 members are sitting on it. Where were the judges? Was it that the judges had already been told to come? So as soon as it was filed, then they went into it. Because usually the Supreme Court doesn't sit on Fridays. So how? Where were the judges that within such a very short time they appeared and then they were dealing with the case? You can see that this decision, it has eroded the confidence, seriously eroded the already reduced confidence that citizens have in the court. This decision has really hurt us for generations to come. It would hurt the Supreme Court. I don't know why they are just so much in an indecent haste. It's bad. It's really, really, really bad. Yeah, because you see, on very critical matters like that, what a court usually does is it says, no, I'm not granting an ex parte application. You see, so what Atenio Martin and Joe Darcy and those people sent to the court is what we call ex parte application, meaning they've sued the speaker already, but they are saying that something went wrong, something is going wrong, very, very urgent. So if they don't get the Supreme Court to step in, then it means that by the time, if you use the normal rules, so you see that law very complex. We have different rules. So if you use the normal rules, which is that go and find Speaker Bagbin and serve him, because that is their case. Their case is that because it's difficult to find him, and really it's because previously the Chief Justice had agreed with the Speaker, and they came out with a practice direction that the Speaker will be served only on Mondays through the legal department. So you see, that was a Friday, etc. So meaning that they could see that by the time they get Speaker, too much harm would have been done. That's their claim. And I'm saying that, no. So what the court was supposed to have said to see that the Parliament is not sitting till tomorrow, 22nd. And they filed that application on Friday. So there is Saturday, there's Sunday, there's Monday today. So why was the Supreme Court rushing? Because if the claim was that the minority, NDC, say they are now majority, so tomorrow they will reconstitute committees, etc., do many things that will disrupt government. That's going to be tomorrow. And I made the point that under our law, the Supreme Court could have sat yesterday. It can sit today. So I was saying the point that it could have sat Saturday, Sunday, etc. Because in table number 4 versus Attorney General number 4, that's the one the Supreme Court said 48 hours is 48 hours. So police cannot arrest somebody on Friday afternoon and keep him till Monday on the pretext that, the court doesn't sit Saturday, Sunday. No, the courts have been open. If you go and apply, you know the right thing to do. The court will sit on Saturday or Sunday, etc. Right? I've attended some of those court sessions. So knowing that that is the law, there was no need for the Supreme Court to rush. Even assuming the justices feel inconvenient coming to court Saturday, Sunday, there is today Monday. Monday is a working day. So why were they rushing? Things like that, we don't grant it ex parte. You want to restrain the Speaker that suspend his decision. The Speaker is in Ghana. It's not gone to Mars or space. So take your time and find him. There's today Monday, if you didn't want to do. And as I was even saying, if the speaker was dodging service, okay, refusing to be served because, let's say, that was Friday that he filed that application, Saturday, because the speaker can show you. When we finish, you can send me hi. I'll send you the circular. Have you seen the circular where the Chief Justice agreed that speaker be served only on Monday? Have you seen it?
I've heard a speaker make mention of it, but I've not seen the circular itself.
After this, or even as we are talking, let me see. I think I have your WhatsApp there. I'll just forward it to you. So I can imagine that if they have difficulty, because they know the speaker will say, no, today is not, Friday is not Monday, Saturday is not Monday, Sunday is not Monday, so he will make himself available. So I said the Friday, the Supreme Court has inherent jurisdiction. They could have made an order that, listen, no, or rather give an order that let the bailiff try to find the speaker on the rest of Friday and Saturday. If Saturday by 8 p.m. they don't find him, then go ahead and publish that there will be a hearing on Monday. Publish it on radio, that's electronic, various types of mass media, electronic, print, social media, etc. Yes, go ahead and publish it. Yes, the Supreme Court could have made that order. So that's how come I'm surprised that they were rushing too much, and now there's been a travesty of justice. And it's not just the travesty alone, but now they've set the court because the little trust that was left is gone. The Supreme Court has set itself too bad because people just say this is politics, and you hear various people. Already people had such suspicions, all right, and they've been making those comments. You remember what led to unanimous 7, that name that they gave the Supreme Court, that is unanimous 7. And it's true that the Supreme Court is a political court. It's not hidden. But the main difference is that Ghana, because of our level of development, most of our people are not yet that enlightened about the court system, etc. So we don't like mentioning that fact. We like to make it look like, oh, the justices, there's no political element. When it comes from the Supreme Court, it's sacrosanct. So that it helps people to obey the decisions, etc. But it's inevitable as people get educated, that thing that is a political court will keep coming up more, right? But the Supreme Court has hastened, they got it quickly because of this brazen manner in which they went about sitting on this Friday. Because everybody see that, oh, it's just the politics of it. They just did it to save MPP. Then people will say, so who appoints Supreme Court judges? Is the president, right? Yes, there's a procedure, but ultimately the president looms large, okay, in the procedure. So largely, yes, I know it will go from Judicial Council before the Presidency, Council of State, but we don't know how the executive wields so much power. So for all intents and purposes, effectively to say the president, you are not wrong, right? So that is it. So what is done is hurt the court, it hurt all of us, because we've all suffered a reputational damage. All of us lawyers, they say, you see, you guys, that's why Rollins didn't even like too much court this thing, because you guys, this is all that you do. You say, yes, it's bad. It's bad. We've been hurt badly by that brazen manner. The speed was too much. The speed of lightning. When we still have today, you have Friday, Saturday, Sunday, today. Parliament is going to sit tomorrow. So that agency has not been proven. It's not been made out. Parliament was not going to sit on Saturday. So the NDC, who are now majority, were not going to reconstitute their committees on Saturday, not on Sunday, not on Monday. It's going to be tomorrow. So why did the Supreme Court rush? Even look, let me tell you, there's a case called Kwame versus Pieni. When Kwame Pieni wanted to become presidential candidate of the MPP in 1996, long story short, they sued. Rosemary Ekwam sued Kwame Pieni that he's disqualified because he had been convicted for some offenses that, in essence, amount to treason. Yes, so the argument is that the offenses he was convicted of, they are not called treason. But listen, if you look at the substance of those offenses, what Rosemary Ekwam argued in court, of course, through her lawyers, is that, look, Kwame Pieni, you've been convicted of treason, trying to overthrow a government, so you cannot stand as MPP presidential candidate. So they went to court for ex parte injunction, like so similar to what happened with Martin Jogate and lawyer Baby did. The Supreme Court looked at it and said, no, this thing, we cannot grant it. Go and serve the MPP. Yes, they didn't grant it. So such very sensitive matters, especially a matter involving a Speaker of Parliament. Yeah? So there's also an arm of government, ordinary jurisdiction. The judiciary is not any more powerful than Parliament. So that's not what the Constitution says. Everybody is under the Constitution. The judiciary is not superior to Parliament. So when you do this type of thing, then you see that people, the only thing people will see this thing, what do you call it, politics. Because when I don't forget, it's not as if there is a different book which has answers to the law, which the rest of us lawyers cannot see. And only some people can see that book, or only some people read that book. No. It's the same training that we get from law school. Okay, lawyers and judges, the same thing. So you come out of law school. If you want to be a lawyer, you stay as a lawyer. If you want to be a judge, district magistrate, they're the smallest court. Nowadays, you can go straight. And usually in the past, you have to practice 3 years. But I think they've removed that law or so, right? So the point, and high court, you need 10 years. Court of Appeal, 12 years. Supreme Court, 15 years. So you need to work as a lawyer for 15 years. After the 15 years, anybody, you qualify, provided you don't have issues of moral turpitude. You've not been convicted of dishonesty and those things. So the point I'm making is that what the Supreme Court looked at and did the decision they did, I'm also looking at the same laws and I'm holding a different opinion. It's not as if there's a different book, that the different law book that only the Supreme Court, the court that starts on Friday, has access to. No, it's not a different book. It's not any different law. It's the same books we all use and we all interpret. So
aside the matter of the rush, you also disagree with the Supreme Court?
Sorry?
Aside the matter of the fact that you have a problem with the hurry and the rush with which the matter was handled, you also disagree with the Supreme Court?
Yeah, you mean the substantive?
The substantive,
yes. They've not yet come into this substantive decision. So, but they've made comments that are suggesting a bit where they are tilted towards. So let's say where the indication is going. So we cannot be definite that they've stuck out their necks that there's been total deprivation. No, this is the initial one. But the way this initial ruling is going, it's pointing in a certain direction. Yes, and I'm saying that direction they are going, I disagree, because it's very clear. If you read the MPP Constitution, it says, Article 3, Clause 9, it says if you go and file as an independent candidate, you automatically forfeit your membership. The word is automatic. I'm sure you've seen it. Have you seen that thing?
Yes.
The MPP Constitution. So
yes.
Clear. The word is automatically. They are not waiting for any other thing. No. The word is automatically. So what is this rocket science about this again? You don't need any other thing. If you do that thing, so what could you have say, Mamile Morrison, and then so the two of them, once they left, they've gone to file as independent, they automatically lose their membership. So they are not members of the MPP. Okay. And yet they are still claiming to be members of Parliament. So in that case, they seek to remain in Parliament as independent. So you go to the Article 97, Clause 1G. It says either you join another political party or you seek to remain in Parliament as an independent. So Kodja Asante, that's the is that the Suhum side?
Yes, the Suhum MP. Yeah.
Suhum MP, and then Mamle Morrison, right? So with what they've done, it means that they are seeking to remain in Parliament as what? Independent, because the MPP Constitution says they are no longer members of the MPP automatically. You don't need any other institution or something to do anything. No, it says automatically. The word automatic is too clear. That one there, let's not make any mistake. So that's how come I don't agree with the Supreme Court, where they are regarded people will be deprived of what? Membership. I'm sure people have already raised you SAL. The SAL decision, when it came before the Supreme Court, it was clear that the people of SAL were going to be denied MPs for 4 years. Yet the Supreme Court didn't make an exception for them. So why is it that this one that even is clear in the Constitution, and thankfully it's only for about 3 months that the people will not have MPs? The Supreme Court is now crying. Meanwhile, the SAR question, when it came before them, the case done by lawyer Supreme Court, when SAR was they sought to create the SAR Constitution constituency in 2020, the issue. The case went to the Supreme Court. They said yes, you can create SAR, but not taking effect in 2020. And so that's how come the people of SAR, Santofi, Asafu, Like, and Lolobi, they didn't get an MP. For 4 years, this same Supreme Court, it's their own decision. They said, look, no, that thing will take effect in 4 years. Supreme Court didn't make any exception. So how can the same Supreme Court come and be crying over a period of just 3 months from this October to January 7th? It's just barely 3 months. Okay? Mm-hmm. So it just tells you the Supreme Court has hurt all of us, lawyers and the bench, everybody, before they hurt totally. Their confidence is eroded massive. They say, you see, we've been telling you, and this has not helped because it comes on the back of the Japa tape, where you find Godfrey Dami going to the house of the Supreme Court judge to go and negotiate, do things like that. So, no. This has been this last few months have been bad for all of us in the court.
I have to let you go, but before I do that, is there any way the Supreme Court could have avoided the politics of this whole issue? Because this issue is clearly political.
No, that one is debatable, okay? If somebody says he wants the court to go into the matter, yes, the thing is very clear. The Supreme Court cannot just, yes, even if the Supreme Court is going to sack the person, Supreme Court has to listen to the person before sacking. So this is how when I say sack, that's to dismiss the case. This is how it works. You have to file the case. When you are filing the case at the registry, and rightfully so, nobody stops you. Nobody stops you. The registry, you pay your money, even if your papers are bad. Well, if the papers are very, very bad, maybe not well drafted, and the registrar is free, maybe there's no pressure, he can identify and say, oh, lawyer, you forgot to add this, blah, blah, blah. But if he's busy, you got your papers, they will collect the money and they file. So it will go before the court. So the court has to call it before they will now say, hey, lawyer, you left out this. So the case is too bad, then they'll throw you out. So it's not possible to say that the Supreme Court will say, no, don't come here. So the main concern, you and listeners need to pay attention to that at the point of filing, and that there is no police or soldier to stop you. No. Any papers you bring, once you say in the Supreme Court, this and this and this, they will accept them. Then, because it's bad, the court has to call the case and ask you to defend. Of course, when it's too bad, you cannot defend. So in 2, 3, 4 minutes, you'll dismiss it. So, but if it's a bit good, blah, 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 you get more time to argue. So, simple answer, it's not possible for the court to just say, no, don't come into this court. What you are talking about is done in the U.S., where if you file the case, before you get to come to court, the court will read through. If they think you shouldn't come here, they will just do that, don't come, then dismiss it. You will not appear in the court. But Ghana, from the way it's done, is before the court. For it to be dismissed, they have to call the case. They will enter the court and argue. Of course, that's what I said, but if it's too bad, they will limit you 1 minute, 2 minutes, or whatever.
Laura, thank you very much for speaking to us this morning.
You're welcome.
Clearly, as a lawyer and an officer of the court, he felt the Supreme Court should not have gone there at all. The way they handled this matter only goes to further damage the reputation of the courts, of the judiciary.